You are placing from which paper book?
But I think there is only one paper book.
No. One appeal by the board. One appeal by the board.
You are the appellant.
Where I am the appellant.
So you have to be on our left hand side.
Oh. Your left hand side.
No, let it be changed.
No. That what?
হ্যাঁ ওটাকে দিয়ে দে
যেটাই তো বললাম স্যার
আচ্ছা আমার একটু ছিলেন তান্ত্রিক কিছু
You are placing from which paper book, Mr.
Milord MAT 873.
873.
873.
It is bottom.
Well, it's item number 21 in today's list.
Yes.
সকলে বসার কোনো ইচ্ছে নেই
শুধু আমার চেহারাই দেখা যাচ্ছে
বেরিয়ে আছে
Yes, Mr.
Milord, in this appeal, Milord, the board is before the appeal court, Milord, challenging an order passed in a writ petition, which was filed by 140 writ petitioners, Milord, challenging, Milord, a recruitment process, Milord, which was initiated in the year 2016 by the West Bengal Board of Primary Education.
Yes.
Milord, I would like to, Milord, take your lordships first through the writ petition before, Milord, placing the judgment under appeal, because we have got a lot to say about the confines of the writ petition and, Milord, how it has been expanded, Milord, contrary to, Milord, all the procedures that, Milord, are available, Milord, in the judicial system.
Yes.
But if your lordships may kindly take the writ petition, which starts at page 36. But I am starting from internal page 28 of the writ petition after the cause title.
Appellant is board and its chairman. Its functionaries are there.
Board president and secretary.
All right. Yes.
But unsuccessful candidates are before the High Court in the writ jurisdiction. Please take, Milord, page paragraph number 3 onwards. Your petitioner states that on 19/10/2012, the West Bengal Board of Primary Education published notification for recruitment of assistant teacher in primary schools. It is needless to say that there were huge irregularities in TET 2012 and several cases were filed. In spite of irregularity and illegality, 18,000 teachers were recruited, and Government of West Bengal gave one exemption to the aspirants of TET 2012, that the aspirants of TET 2012 can sit for the next examination, and in that case they shall be exempted from paying any fees for the examination. The petitioner states that on 12/11/2014, NCTE published a notification dated number so and so, and in that notification, qualification and other procedures for recruitment were prescribed. Paragraph 5, your petitioner states that on 9/4/2015, Ministry of Human Resource Development published a notification under so and so dated 9th of April 2015, extending some relaxation to the state of West Bengal till 31st of March 2016. Your petitioner states that on 14/7/2015, Government of West Bengal published a notification framing certain rules disclosing about the requisite qualification, etc. Then 7 is, your petitioner states that on 11/10/2015, TET 14 examination held in West Bengal, where huge number of students appeared. It is needless to say that on the date of examination, the notification issued by the MHRD was in force, and all the students who passed and or qualified in TET 14 should get benefit of the notification of 9/4/2015. Your petitioner states that on 2/3/2016, the recruitment rules of 2016 was notified, and Rule 6 of the notification speaks about qualification of persons who are seeking and or eligible for appointment. In clause 6, subclause 3, some specific guidelines are there for non-trained teachers. It is needless to say that all TET 2014 candidates are entitled to get benefit of this instant rules and the notification issued by MHRD. Your petitioner states that on 14/9/2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26/9/2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. Or in other words, Millard, first the trained candidates will be appointed, and for the rest of the vacancies, untrained candidates. That was the relaxation. It is needless to mention that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have the training will be considered too. The notification proves that the board decided to give something of the relaxation benefits of relaxation to all TET 2014 qualified candidates. Your petitioner states that after the notification, the procedure was started for appointment from October to December 2016. The interview and verification started on 31st of January 2017. Allegedly, the merit was declared, but there was no panel, there was no merit list, there was no category-wise, merit-wise, no division of numbers, and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether she was impaneled or not. No merit list was ever published, and in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 31/2017, list of trained candidates were published. On 4/2/2017, list of non-trained candidates other than the Bengali medium was published, and on 8/2/2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and the list, it is clear that all trained candidates of TET 14 were appointed through the first list, and after completion of the same, as per notification of 2nd March 2016, the board appointed non-trained candidates. The board stated that they shall publish more lists, but those lists were not published. Your petitioner state that on so-and-so date, notices were published for recruitment as assistant teachers in primary schools from TET 2014. The board has appointed non-trained teachers after 2016 even, and intentionally ignored the petitioners by giving excuse of notification of MHRD by way of so-and-so dated 9th of April 2015. Thousands of non-trained students were appointed, and petitioners, those similarly placed, were ignored. But this is the only case. Petitioners who were similarly placed were ignored.
They were also non-trained.
Untrained candidates or non-trained candidates. Untrained. If it is the stand of the board that no non-trained candidates can be appointed, then all the appointments of non-trained candidates made after March 2016 are bad in law. The relaxation given by the NCTE is applicable to all in any TET 2014 candidates who qualified in the examination.
So the board appointed untrained candidates. The petitioner says that I am also an untrained candidate, but you have not included
me, or you have given deprived me and given appointments to other non-trained candidates. But this is the short case. Now this has been stretched to I should say, Millard, and illogically extended, my lord, adjudication of the matter. Your petitioners state that recently the TET-14 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23rd December 2020, the West Bengal Board of Primary Education published one notification of recruitment of 16,500 primary teachers. This is the subsequent recruitment process. I don't think I need to trouble your lordship with this part. Then 13 Millard, they give examples of 4 persons who were allegedly non-empaneled, but they got appointment. And then Millard, kindly take Millard, paragraph 14. Your petitioner states that at present there is more than 1 lakh vacancy in the education department. Since 2011, several examinations were conducted to fill up the vacancies in the school, but a single recruitment procedure could not be completed without corruption and irregularities. The qualified students were not selected. These are all prejudicial facts. Then, Milord, paragraph 15 is where one honorable member of the parliament had made certain comments. The others are MLAs who have made certain comments. Then paragraph 16, biggest scam, TET-14 is the biggest scam. Para 17 again, TET-14 is the biggest scam, and 14 to 20 lakh rupees were exchanged. Then kindly take me at para 18.
So you were unsuccessful in TET?
The writ petitioners. No, they were successful in TET, but as your lordships know, TET is a qualification for applying as for recruitment for the
one of the. So they passed TET.
Yes, so far as passing of the TET examination is concerned, there is no dispute.
Now they are saying that TET
that they have been, yes, what their case is that they also fall within the untrained or non-trained category.
Who were not successful in TET?
No. Everybody are successful, because unless somebody is a TET qualified, like I can apply for enrollment only if I pass the LLB degree course, or I can apply for judicial service provided I pass the LLB course. So therefore, TET is like a qualification, isn't one of the eligibility criteria. Your petitioner states that the board has started different cases before this court, that 42,897 candidates were selected till date, but no merit list of the candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, and a reservation category-wise list should be published. Candidates were informed through SMS, and no merit list of so-and-so candidates were published, and it proves the mischief in the recruitment process. If the process was free from all corruption, then there ought to have been a transparent merit list of so-and-so. The process was not completed in February 2017, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET-14 were appointed as primary teachers, but these are all submissions without any proof whatsoever, any evidence whatsoever. Be that as it may, I will deal with each of the allegations. Were appointed as primary teachers by the board, and in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have given suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET-14 qualified candidates were not issued to them, and even today they were fighting for that. There is no delay in filing the PIL, etc. I do not know from where they have copied this, but this is there. Then para 19. The petitioners state that your petitioners are hailing from poor families, and if they were recruited in time by giving them opportunity of being trained, etc. I don't think that these are that important. Then para 21, 22, they all speak of corruption everywhere, and then are the grounds. Now, what is very, very important is the prayer and the date of affirmation of the writ.
You tell us what was their pleading based, what were the arguments they were advancing?
Millard, I can speak of the argument provided, my lord, the proceeding was confined to or limited to the pleadings and, my lord, the affidavits in opposition and the replies.
According to you,
Yes.
what
There
are
was
the
no argument.
what were the contentious issues?
My lord, there were no argument. Now, my lord, I'll place the judgment. There was no argument.
No,
But I would start from placing judgments before this court, that what is meant by a judgment and what should be the characteristic of a judgment.
No, according to you, Mr. Dotto, on the pleadings, what were the infirmities they pointed out?
My lord,
Just point one was untrained, similarly situated, not
but this is the only part.
no merit list was published.
No merit list, my lord, that, my lord, I'll satisfy, my lord. Yes.
Third is there are discrimination among certain persons.
3 or 4 examples were given. 3 or 4 examples given.
So primarily it is think that I am unsuccessful.
Yes.
So you turn down the entire.
No, that was not the prayer. That was not the prayer. Now please have a look to the prayer. But I will take your lordship, my lord, from the very first order which was passed in this writ petition. But this matter has, my lord, very many facets for your lordship to decide, in addition to the merits of the matter. And
It has not come up in appeal against
no, because the entire recruitment process is conducted by the board.
State is also
Conducted by the board.
Yes, show us what you are showing.
Yes, now kindly have a look to the prayers. 47. At page 47. Prayer A is Rule 26 dispensation. Prayer B. A writ of in the nature of mandamus be issued directing the respondent authorities as follows: to act in accordance with law, to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from TET 2014, including the date of recruitment. To direct the authorities to treat the petitioner equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given by MHRD on so and so. To recruit the petitioner by giving them the same benefit by which the other non-trained candidates were recruited by the board by following the rules dated 2nd of March 2016 and appointment notification dated so and so. Direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment to protect the records, etc. Such right. And my lord, in this writ petition, my lord, 36,000 appointment has been set aside without any prayer.
Yes.
The date of affirmation is very important. 12th of September 2022. In respect of a recruitment drive in the year 2016.
When was the last appointment made?
Last appointment
2017. Apart from
Please ask your junior to.
Yes, 2017 February. But in addition to that, Miller, there are certain court orders. Under court orders also appointment made, but
subsequent to 17.
Subsequent to 17, but these are all under court orders. But so far as the board is concerned, in the recruitment process, the last appointment was made in February 2017. Recommendation.
Yes.
Now, Miller, I need to, Miller, take your lordship, Miller, through the orders passed by the learned single judge from the day of entertaining the writ petition. But judgment period under appeal, my lord, I'll come later on.
Yes.
My lord, your lordships may kindly take me the third paper book, page 418. আচ্ছা আমাকে পেজ নাম্বারগুলো বলে দিতে পারেন। 6/2/22 কত তারিখ?
চারশো
এই কত পাতা? 6/2/22
418
6/2/22
no
415 it's done.
415 see
তুই আমাকে 6/12/2022 পাতাটা বল। Please take me to page number 415 first. This is dated 6th of December 2022.
yes
The petitioners appeared in the 2016 recruitment process. All of them are TET qualified, as has been submitted from the bar and pleaded in the writ petition application. The petitioners came before this court after the documents and marks produced before the division bench, headed by the Honorable the Chief Justice, in one of the matter which was first moved before me, and I adjourned the matter, seeing the nature and character of the same as a PIL, and sent it before the Honorable the Chief Justice.
this is not the writ petition against which this appeal is coming.
Yes, this is the writ petition.
Two double
No, the one which is referred is another. Yes.
Then why we are going into
No. This order is passed in this writ petition. 6th of February, December 2022. This order is in this writ petition.
this is this appeal is arising out of 21187.
Milord, these are.
What is your writ petition number? This
WP,
21187.
WPA 21187 of 2022.
so this is your their writ petition.
Their writ petition.
This is the first order in that.
Yes, it's in fact the third order, but the previous orders are not not that important.
Yes.
Then, Milord, the next paragraph is the petitioner has come to learn that in 2016 recruitment test, a large number of untrained candidates were given recommendations and appointments by the West Bengal Board of so-and-so and the respective councils. The petitioners given a large number of candidates were appointed who got marks below the petitioners. The petitioners got this information from the learned advocates who inspected the concerned list. The petitioners submitted despite their marks being higher than the untrained candidates of 2016 and were called in interview and aptitude test. None of them were called in the interview. Learned advocate for the West Bengal Board of so-and-so has drawn my attention to the prayers and have stated that in one prayer the petitioner has prayed for publication of some information which are already in public domain. But I am told by the petitioners that the petitioners' breakup of marks are not in the public domain, as the candidates who were recommended, only their marks have been uploaded. Learned advocate for the board has also raised the question as to whether the petitioners applied for the recruitment test of 2016 and whether they were called for interview at all. After considering the submissions of the parties, I direct the petitioners to disclose the application filed by the petitioner and call letters for interview of the petitioners by filing supplementary affidavit. The petitioners shall also disclose the documents as to their training qualification, if any, taken by them. The training qualification documents, if any, shall also be disclosed. Or Milord, the court is inviting documents from the petitioners. Why this is important, Milord, as I progress, your lordship would find. Kindly take the next order of 20th of December 2022 at 418.
Yes.
The case of the petitioner in short is that though the petitioners got higher marks before addition of marks against interview and aptitude test, comparing to some of the candidates who have been given the appointments against 2016 recruitment process ever after adding their marks for personality test and aptitude test, they have not been given appointment. Please mark this last sentence of the court. The petitioner's case is that interview was also held, aptitude test was also taken. But why this is important, I'll come later on, because the judgment proceeds on the basis that no aptitude test was taken and the honorable judge had called witness, cross-examined the witnesses. A complete unknown procedure. allegedly in exercise of power under section 165 of the Evidence Act. But please mark this sentence that it is the case of the petitioners that adding the interview marks and aptitude test marks given to them, they were not given appointment. This is the recorded case. Though, my lord, it's not there in the writ petition, I had placed the entire writ petition before your lordships. They have come before this court as have been submitted after taking inspection. I'm sorry.
Though the petitioners got higher marks, this is higher marks on which evaluation? This is prior to the interview.
No, but after completion of the entire process, according
Said that though the petitioners got
higher
higher
marks
before addition of
of
marks
marks,
before interview and written.
yes.
So prior to this interview and aptitude test, there was any further rider?
My lord,
Or
as your lordships know, my lord, there are certain marks for academic qualification which is added. These are those marks which, upon addition,
of academic qualification, they got higher
marks.
marks.
This is their case. But what is very important over here is, my lord, finally, my lord, the honorable court has not gone into this. The judgment which is under appeal before your lordships proceeds completely on the basis that no aptitude test was taken, therefore entire process is bad. I'll come to that, but this is very important. How, my lord, the stand is getting changed from time to time. Therefore, my lord, the first positive assertion is recorded in the order of 20th of December 2022. They have come before this court as has been submitted after taking inspection from the records produced before the Honorable Chief Justice's court in a public interest litigation, and they have also got some input from the publication of marks of the M-panel candidates. In respect of WPA so and so, the present one, the petitioners have prepared a tabular chart of 139 candidates, and the petitioners submit that all those 139 candidates have got higher marks than the last employed candidates, but they have not been given appointment. Pausing here for a moment, this point also I will be taking that these tabular statements, my lord, are not pleadings. There has been no amendment of the writ petition.
Yes.
Mr. Ratul Bishwas, learned advocate for the board, prays for some time to check the marks of so-and-so, making appropriate submission so-and-so. For this purpose, I fix so-and-so. Along with the matter, such and such are being moved, I direct so-and-so in for application to supply similar tabular sheets to Mr. Bishwas, and Mr. Bishwas will come after verifying. Mr. Bishwas is also directed to come with particulars of the tabular form, etc., etc. Then please take, my lord, the next order. This is very important for me. 17th of January 2023. Kindly simulate the turn of events from here. But as I said, my lord, your lordships.
Yes.
But I would invite your lordships not to only confine to the merits of the judgment. The procedure which has been adopted in the adjudication of the instant writ petition is very important, my lord. Otherwise, my lord, for the future, my lord, this will remain in the records of the Calcutta High Court.
Page? Which
page? Page ta bolto?
Page 421.
Page 421, 17th of January 2023.
Yes.
In course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, when the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test there are 5 marks are there also for interview. Completely contrary to the previous days, my lord, recording. Please come back to Millard, the previous order.
Both were held.
Both were held, marks were added, and thereafter, people who got lesser marks were appointed, petitioners were deprived.
Herein they say that there was no interview.
No aptitude test. Interview was taken, but there was no aptitude test. Though in aptitude test, there are 5 marks. Or under the rules, Milord, for aptitude test, Milord, 5 marks are allotted. Interview 5 marks, aptitude test 5 marks. So a completely contrary case. I do not know who has made out, but it is recorded. Now kindly see, Milord, the Honorable Court takes upon itself the power under section 165 of the Evidence Act. As a large number of petitioners were present in the courtroom, this is the reason. So many petitioners are before your lordships, therefore, Milord, the law is going to change. As a large number of petitioners were present in the courtroom, I decided to exercise my power under section 185 of the Indian Evidence, and I asked some questions after administering oath to 7 of such candidates, being petitioner numbers, etc.
Yes.
Milord, section 165, as your lordships know, Milord, this is exercised by the court or the judge in course of trial to elicit, Milord, some points which may have been left out by the prosecutor or the cross-examiner, or to get some clarifications if required. Or if the court finds that the cross-examiner is not putting the right questions. Now the court, Milord, takes upon itself the burden, in my very respectful submission, a misconceived burden. Kindly pardon me, Milord, for adding this expression, of exercise of powers under section 165.
Yes.
First, Milord, the judge holds the trial. Then the trial is over in the next sentence. Please have a look to that.
Yes.
The next page, Milord. From their evidence, I am satisfied that there was no aptitude test for the said petitioners. Trial over. Finding given.
Yes.
Learned advocate for the board has submitted that he does not have any idea whether such aptitude test was taken or not. In such circumstances, now, Milord, the court is eliciting, Milord, documents, evidence. In such circumstances, I direct the president of the board to file one affidavit by 7 days from the date disclosing whether there was any aptitude test in 2016 selection process and what is the method the board is following this year to take the aptitude test of the candidates. It goes, this year means, Milord, it goes beyond the writ petition. This was 2023. When, Milord, the 2022 recruitment process was ongoing.
No, after this 165 episode, your advocate was asked that you submit the documents. Writ court cannot call for documents, Mr. Doctor.
Yeah, definitely. The writ court has the power of certiorari. The writ court can definitely call for documents, but not allegedly after exercising power under 165. Milord, your lordships have the power. In a case, Milord, your lordship finds that there is some disputed questions of fact which can be resolved by way of production of documents, because disputed questions of facts are not always barred for adjudication by the writ court. No quarrel on that issue. But situation under which, Miller, the writ court exercises its powers in adjudicating disputed questions of facts are where your lordships find that from the documents on record, a disputed question can be adjudicated. And for that purpose, Miller, one or two documents here and there missing, your lordships may call for that.
You did not challenge these orders at that stage.
No, these were not challenged.
Yes, next, what you want to show?
Yes. Then, Miller, the president of the board is directed to, Miller, file an affidavit that was filed. I'll take your lordship, Miller, in the pleading sequence. Now, kindly take note the next order dated 24th of January 2023.
Yes.
I directed the petitioners that at least 2 candidates from each district are to be present before this court, as the court wants to know from them about the interview and the aptitude test taken by the board in 2016 selection process. Millard, parties call witnesses.
Yes.
Both under the Civil Procedure Code as well as, Millard, the Evidence Act, it is the party to a proceeding who calls their witnesses. Court is not powerless. Court can also call, Millard, a stranger to come and depose. But ordinarily, it is the parties who are to produce their witness,
yes,
in a trial. Of course, Millard, I need not, Millard, dilate before your lordship that these trials are not held in the writ jurisdiction. But kindly consider, Millard, how the case proceeded. So I directed the petitioners. Or, Millard, my submission is the court calls witnesses over here.
Mr. Dotto, this has merged with the final order.
This is, Millard, this is why this is essential. Why I am troubling your lordship with all this is that finally, Millard, my point would be predisposition of mind of the court. Now, in order to prove this predisposition, Millard, how the case was conducted is required to be demonstrated before the court.
Yes. Which page next?
Millard, 24th of January order. Kindly take the last 2 lines. I am told by the learned advocate for the petitioners that the candidates are present. Now I start exercising my power. Under section 165 of the Indian Evidence, as I want to take evidence of the candidates from each district. Well, a procedure completely unknown. Millard, for a moment, Millard, my submission is not that the writ court cannot take evidence. Millard, there are exceptional situations where the writ court can take evidence. This is not one of those where the court elicits documents, the court elicits Millard evidence for the petitioners. The court is collecting materials for the petitioners. I'll gradually, Millard, I'll demonstrate before this court. That is, Millard, a procedure which is not permitted by law. But the Millard writ proceedings are, Millard, Order 19 proceedings. They are adjudicated based on the affidavits that are filed before the court, and whatever they are annexed to those affidavits and the writ petition.
Allegation was a scam to whatever may be the procedure. The court, Mr. Dotto, cannot go to the nitty-gritties.
Now, what was the final? Yes. But Millard,
I understand your argument. Now you tell us that whether it is absolutely you are showing, you said so, that predisposition of the court's mind.
Yes.
That these were the rudiments on the basis of which the court has come. Yes. Then
Millard, now I start, etc. Some names from each district have been intimated to me by the learned advocate for the petitioners who were candidates in the 2016 recruitment process and appeared before the interview board, but all of them were unsuccessful. Though the name of one Shankar Thapa representing Uttar Dinajpur was mentioned in the list handed over to me by the petitioners, Mr. Thapa is not present, and I have taken evidence of 19 candidates exercising my power under section 165. I have received the affidavit as was directed by this court on 17/1/23, affirmed by the president of the board, which is kept on record. The instruction of the board under memo dated 11/1/23 was shown to the court and handed over to the learned advocate for the petitioners by the board. The petitioners have come up with one exception considering the said memo, that is the instruction affirmed on so and so, which is also kept on record. The respondent board wants to deal with the said exception. The board wants to file one affidavit in opposition to the writ application for which no prayer was made and therefore no direction was given. Now at this stage, when the evidence of a large number of petitioners have been taken, which are throwing light upon one of the allegations of the petitioner, I will not allow filing any affidavit in opposition in this matter by the board. I direct that another affidavit is being directed, the president of the board to file one affidavit further explaining what is an aptitude test, and this explanation is to be given after consulting the experts in the teachers training field, and the names of the experts are also to be given to the court in a sealed cover, and it will not be disclosed to the petitioners. The president of the board is also directed to produce one list in a sealed cover, which will not be given to the petitioners, which will contain a list of names of the interviewers and their designation in respect of the interviews of the candidates whose evidence has been taken by this court. This list shall remain a secret list, so and so. Direction given to the petitioner, etc. Then, Millard, your lordship may take, Millard, the next one where, Millard, seal cover proceed. I mean, everything was given in seal cover. That is where that is recorded here on the 6th order of 6th of February 23. Page cover at page 427.
Yes.
Please take note of the second paragraph. First paragraph is the affidavit was filed by president as directed. Second paragraph is the letters issued by the board to different experts as to aptitude test were in a seal cover which has been opened in court, and those letters were kept inside again after perusal of the same by this court, and that envelope should be sealed again. Another sealed envelope containing list of persons who took interview of different districts, namely districts of so and so, have been produced, and those lists are contained in small sealed envelope which are kept inside the big sealed envelope. Out of those interviewers, the envelopes in respect of the district of Hooghly, Howrah, etc., has been opened and kept in a separate file. The other small envelopes in respect of other districts have not been opened, and they are kept in a big envelope, and that big envelope is to be sealed again. Out of the interviewers of the following districts, namely so and so, I need to know some facts about the interview and aptitude test, and whom I call for appearing before this court on 21st of February. So now,
Yes.
now, my lord, interviewers are being called, and I call for and whom I call for appearing before this court on 21st February at 2 p.m. and the expenses of their journey, etc., I do not want to saddle. The amount to be paid is so and so. I do not call all the persons' name. For the district of Hooghly, I call persons named in serial number so and so. Then other districts so and so. On 21st February 23, this proceeding of asking some questions to the interviewers would be done in camera, and their reply to the questions would be recorded. List this matter on so and so. The board is directed to so and so. Now, please take, without skipping over one order, please take the order of at page 432. This is also of 6th of February. Where on the same day, two orders were passed. One in the first session, the other in the second session. The second session order is at page 432.
432.
Yes, madam.
কি বলছে? No, yes.
But this is in the second half. Pursuant to the order passed.
Date returnable was 21st February in the earlier
one, but this
was taken in the after.
Yes. Pursuant to the order of passed on 6th of February, evidence of the following named teachers who took interview of some candidates in 2016 recruitment process for so-and-so conducted by so-and-so of the district of so-and-so were taken up. The real question was...
No. Were they those interviewers in paragraph 7 of the earlier order?
Yes. They are the interviewers who were called, Millard,
by the 6th of February order.
Yes.
So they were present in court.
Appears to be so. Thank you.
So thereafter they were interviewed. Very good. Now?
কোনটা এটা 21st হবে
21st February.
ডেটটা wrong
21st August. Yes, that is what is written.
হ্যাঁ ওটা কত হবে এটা 21 হবে
This is 21st February.
আচ্ছা
Oh, not on the same day.
very well, I stand corrected. Huh? But I am told in the website ঠিক আছে বলছে যখন
Very good. This is 21st February.
Yes, when my learned friend is saying similar, I will not contradict.
So on that day the interviewers came. Yes.
So pursuant to the order passed on so-and-so, evidence of the following named teachers who took interview of some candidates in 2016 recruitment, where 2023 these persons are being called. Evidence of the following who took interview on 2016 recruitment process for the so-and-so of so-and-so districts were taken up. The real question was whether the aptitude test of the candidates were taken or not. Well, this is not a point raised in the writ petition. From the table below, the reply to the questions would be found. Where Rabindranath Bhattacharya says no aptitude test, Rafiq Alam says test taken, Prabhat Roy says no test, Ratan Bala says taken, Arun Kanti Niyogi says not taken. Well, some say taken, some say not taken. I'll place Millard, everything was on record that aptitude test was taken at the appropriate time. But Millard, this is what has transpired, Millard, from the examination by the judge. Then after the table, kindly look into this sentence. No questions were asked by the appearing parties to the above interviewers. Matter ends over there.
Because the answer was partly in their favor. Because some said no aptitude test.
Maybe or may not be. What is the legal position your lordship would kindly consider?
Okay.
The evidence recorded are kept on record. It is to be noted that there was no formal engagement letters for acting as interviewer. All of the interviewers were called over phone to take interview. There was no guideline for awarding marks for aptitude test, where the learned judge forgets Millard the rules. A large number of interviewers were not intimated by the board that there is one aptitude test, a different test altogether also beside interview. One interviewer so-and-so said that he took aptitude test, but when asked what was an aptitude test, his reply was aptitude test means confidence and body language of a candidate. Therefore, 36,000 appointments should go. Then please take Millard the next one, which is 5th of April 2023 at page 436. Where the interviewers over. Now kindly take Millard 5th of April.
Yes.
I direct the superintendent of the Presidency Correctional Home to produce Mr. So-and-so physically before this court. The superintendent is directed to make arrangement for necessary police force, etc. But none of the parties had, my lord, prayed that this gentleman should be brought before the court.
Yes.
So this was adjourned till 3 p.m. Now kindly take, my lord, the at 4:20 on the same day, my lord, this order was recorded. This is at page 437.
Yes, page 437.
My lord, 5th of April 2020.
Have you been interrupted by anybody?
Mr. Bhattacharya is sleeping. And I and Mr. Sannal could not find any reason.
You should interrogate him.
Yes. Why should he be drowsy?
Yes, 437.
Well, the second paragraph, my lord. The hearing is not complete. Respondent board will make its submission in respect of the argument made today by the petitioners. Thereafter, the petitioners will be given opportunity to reply to the submissions to be made by the board. Pursuant to my direction, so-and-so was produced before this court by the so-and-so. Some relevant questions were put to him which were required to be known by this court.
Yes.
Some relevant questions were put to him which were required to be known by this court for full and complete adjudication of the matter. Mr. Bhattacharya has replied to that questions which are recorded as below. I am asking some questions to the erstwhile president of the West Bengal Board of So-and-so, exercising my powers under section 165. Mr. Bhattacharya, any selection committee was constituted for the 2016 recruitment process? Yes. The selection committee was constituted by the board. Who published the result and who prepared the result of 2016 recruitment process? The deponent first said that he does not understand the question. Then he said that it is compartmentalized and made some statements as to the compartmentalization. Whether any other outside agency was engaged to prepare the result of 2016 recruitment process, the board has acted in accordance with rule so-and-so of the recruitment rules. The question is, was any specialized agency engaged? Yes. What was the name of the agency? I have to go through the records. I cannot remember. Have you ever heard the name of P. Basu Ray and Company?
Yes.
Your Lordship will not find this name in any pleading.
Yes.
Your Lordships would not find this name in any pleading. I won't say anything more. Mr. Tiwari is here, Lord, he'll contradict me.
Yes.
Answer is maybe, I'm not sure. I have to go through the records. Did you know whether any aptitude tests for the candidates were taken? Yes, of course. Aptitude test was taken. There is no report during my tenure as the president of the board that aptitude test was not taken. Are you sure that the reservation norms were followed in 2016 recruitment process? But another additional factor comes. Reservation. Reservation policy was, as was incorporated in the rule itself, was followed. There was no allegation or information during my tenure that reservation policy was not followed. Mr. Bhattacharya, is there anything against you personally in respect of the matters pending before this court against the board, which are now in the hands of CBI or ED? No personal allegations till date has been made against me. The witness volunteers Without any pretext or context, the Honorable Court has asked me some question and I have given answers to that to the best of my knowledge. Mr. Bhattacharya was handed over to the correction room, etc. Fix on so and so.
Yes.
Order date বল পদচারে এমন কিছু নেই Then on 12th, my lord, we pray for directions for filing affidavit.
Yes.
Then 19th of April also, my lord, the affidavits. Then, my lord, the hearing starts. Hearing concluded. Now, my lord, take the judgment.
12th of April 23.
12th of May 23.
12, page 442.
It's no. I'm sorry, my lord. Yes, but I have it at 611. Your lordship may look from that page also.
611.
Yes,
So
it would be made in the other volume.
But what is this page 438? Or
Well, it's the same judgment. Judgment under the appeal. 12th of May 2023. It's at two places where I have read it here from page 611.
Yeah,
No,
no, final order is 12th of May. Yes.
Now, this is the final judgment which is under appeal.
Yes.
This writ application has been filed by 140 petitioners who were qualified in TET 2014 and participated in the 2016 recruitment process but did not get appointment. The recruitment process was held by the West Bengal Board of Primary Education, which was to be held in accordance with the recruitment rules, which came into effect. Rule 6.3 of the rules in Rule 6, Sub Rule 3 of the said rules, the following provision has been made. In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualification as specified by the National Council of Teachers Education and MHRD, and thereafter the eligible candidates with the relaxed qualifications specified by MHRD may be considered, and if candidates with relaxed qualifications are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with an undertaking to acquire the minimum qualification specified in the NCTE within a period of 2 years from the date of appointment. Under the said rule, Sub-Rule 3, 8 notes are there which would be taken into consideration if required. When the petitioners filed the petition, they wanted the authorities to file a report disclosing name, numbers, rank, category, etc. of the non-trained candidates who have been recruited by the board from 2014, including the date of recruitment, and to treat the petitioners equally with the non-trained candidates, etc. During the course of hearing, the petitioners disclosed various particulars collected from the publication made by the board in its website, showing that there were serious illegalities in preparation of the panel of 2016 recruitment process when viewed in respect of untrained candidates at the time of recruitment, and while disclosing such particulars, they made it clear that all their allegations of illegalities in recruitment were in respect of untrained candidates at the time of recruitment who were given appointment against 2016 recruitment process. And at the same time, it was made clear that they do not have any grievance with respect to the trained candidates who were trained at the time of recruitment and were given appointment in the 2016 recruitment process. Therefore, the candidates who were trained at the time of recruitment are outside the scope of this matter. The petitioner prayed for filing supplementary affidavit, which was granted, and from the supplementary affidavit to the writ application, it became evident that all the petitioners had qualified TET 14 and participated in the 2016 recruitment process, and they were called for interview, but they did not get the job. Milord, the aptitude test calling, Milord, which was recorded in the first order is missing. Now the honorable judge records that only interview. This court directed. Now, Milord, the court is, Milord, inviting or calling for evidences. This court directed the board to file one report as to the petitioner's breakup of the total score sheet of 2014, TET 2014, along with the breakup score of the last impanel candidate in their respective medium category and district who participated in the recruitment process of 2016. From the breakup, the petitioners found that the found and alleged that the particulars given therein are absolutely false, as because the lowest number of impanel candidates was shown in the report as 14.191, whereas throughout West Bengal, 824 candidates who scored below 13 were appointed, and the petitioners prepared a tabular sheet to that effect and enclosed it as Annexure B to their exception to the report filed by the board dated 11/1/23. Such exception was filed in the form of an affidavit affirmed on 24th January 23. It was also stated in the exception that list of the last impanel candidate of different categories, namely General SC, ST, OBC A, OBC B, was not given. I have found that there was no reply of the board in respect of the allegations as aforesaid in the affidavit in opposition filed dealing all the pleadings of the petitioners. From the pleadings of the petitioners, it is found that they wanted the marks of the last impanel candidate of different categories like SC, ST, OBC, etc., but no such particular were supplied and produced by the board despite direction given by this court. In the affidavit in opposition of the board maintained silence in this regard. This is nothing but suppression of facts from the petitioners as well as from the court. In respect of holding of aptitude tests, the chairman of the board in his report said that the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidates, it has been proved before this court that no aptitude test was taken. We are pausing here for a moment, Pilot. All relevant records were before this court, which is part of the paper book, to show that in every district, Willard, aptitude test was taken. But with respect, the Honorable Judge do not refer to any of them. The Honorable Judge confines this adjudication to whatever was elicited under Section 165. Pleadings and evidence on record, Miller, in my very respectful submission, has been ignored. In this regard, the order passed by this court in this matter on 6/2/2023, not challenged till now, is required to be quoted. Miller, that order is quoted, but I placed that order, Miller, with the...
So, Mr. Dotto, where they called for the aptitude test?
Yes. We have all records annexed. I'll not go elsewhere. So this paper book itself.
The evidence which was extracted as you were submitting, that is relating to the issue whether aptitude test was held or not.
The issue which the Honorable Judge considers at the time of final adjudication is only confined to whether or not aptitude test was taken.
Yes.
Although, Millard, no pleading was there. That's why, Millard, I have taken your lordship through the writ petition. Then, Millard, if your lordships may kindly skip over the table at page 617 after the table. No question was asked by the appealing parties to the above interviews. The evidence kept on record. It is to be remembered. This is the quotation of that order. I skip over those. Now, please take paragraph 10. Then page 618, para 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. Paragraph 10.
Yes.
But so long, Millard, the finding was that no aptitude test was taken. The interviewers have made contradictory statements in course of their deposition. Now, kindly see paragraph 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal.
Maybe the judge thought that the aptitude test which has been held is not in terms and in consonance with the rules.
Well, let us simulate whether that has been held or not.
This issue as whether aptitude held or not, this I think will go because subject to what you say. because maybe Lordship was proceeding on the basis that test which was held was a sham test.
Right.
That is, I think, the
Yeah.
ultimate
Milord, there cannot be, Milord, two
versions.
versions. Either the aptitude test was taken. If taken, it is faulty or correct. That can be one situation. The other situation was no aptitude test taken.
Okay.
So long, Milord, we had a understanding from the judgment that
There was no
no aptitude test.
Hmm.
Therefore, the marks given to the candidates against the aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. The board has not given any reply in respect of awarding 9.5 out of 10 marks to a large number of candidates, which is absurd and an impossibility, especially to those whose academic score and test score were very low. The table given below substantiates the allegation apart from 121 pages booklet, spiral binding, which is on record. The spiral binding cannot be a pleading or an evidence.
So who made the spiral binding?
The petitioners, writ petition.
Record with us.
Yes, that we have put in the paper book. It's in the paper book.
Yes.
In support of their allegations as to corruption in awarding marks in the interview, the petitioners have filed a booklet of 121 pages on the basis of which it has been alleged that the candidate whose marks were very poor in secondary, in higher secondary and in TET has been given 9.5 out and 10 marks, that is full marks out of full marks 10, that is the perfect 10 in the interview and aptitude test. No aptitude test was taken at all, and the allegation that there was no aptitude test which has been proved before me. Who has proved this? The proof has to be preceded by an allegation, an assertion, a pleading.
Yes.
But how it has been proved, I'll come to that later on. But before coming to the conclusion that it has been proved,
yes,
one must come up with an allegation. Proved before me from evidences of the candidates and from the interviewers which are kept on record. Here, to elicit the truth, I had to exercise my power under section 165. For example, some particulars have been given in the said 121 pages booklet, which has been prepared from the particulars published in the web portal of the board. By the board, some candidates' marks were reproduced herein below, which shows that the marks awarded to such candidates whose results are very poor in secondary and in higher secondary examination and also in TET are wholly absurd. Assessment in interview, and unless some extraneous factors which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED, such absurd marking could not have been made by the interview boards in different districts. While looking into the following particulars, it has been noted by me that in the academic assessment and TET, 1. The maximum marks that could be given against secondary examination score of a candidate was 5. The maximum marks that could be given to a candidate against high secondary examination score of a candidate was 10. The maximum marks that could be given to a candidate against TET was 5. Therefore, the maximum marks that a candidate can get against the above three heads is 5 plus 10 plus 5 is equal to 20. Now I give example of a candidate before giving a table prepared from the document or record, that is the 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in high secondary out of 10, totaling to 7.378. But was awarded 9.5 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score came to 16 points so and so, and thus he became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Miller examples given. For example, Putul Bormon Singho, total marks in the academic qualification is 7 point something, and the interview marks is 5.0. Similarly, Monimala, etc., etc. This is the Honorable Judge records. Then kindly, after the table, para 15. The board has not given any reply in respect of the allegations of the petitioners in the pleadings as to non-empanelment of the reserved category in the panel for general category candidates of those reserved categories who got better marks than the general category candidates in the open competition. Thus, the board has violated the law declared by the Supreme Court and has committed extreme illegality. Though the relevant Rule 7 of the recruitment rules of 2016 mandates constitution of the selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. It was done by one outside agency, a third party, which was not at all a part of the board, and this third party was named as confidential section of the board. This is clear violation of the recruitment rules. The board has maintained complete silence. From the gross illegality in the selection procedure in recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including the former president who is now in custody, so and so, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidates who made money who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. A former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI ED investigation is being continued now in full swing. With respect, paragraph 17 has got nothing to do with the merits of the matter.
It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
No, right. You have told us that there was
nothing was there. Simply using this catch expression, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
In that case, the judge should first release the matter.
First?
Release the matter with
the
respect.
Perception in the sense from the record.
No, these are not on record. These are the personal views of the judge. But how could the Honorable Court get the name of that third agency?
If it is ultimately shown by them that they are...
Whether it is shown by them, right?
These are all factors inextricably bound. You cannot segregate it without...
No, these were not placed before the court. I'll come to all the pleadings one by one. It has to be there in the pleadings.
The pleadings you have shown.
Nothing is in the pleading. I'll come to the other pleadings. I've just taken your lordship through the writ petition. Other things where and the sequence of pleading is also very important. When did the court invite which pleading? That is also very important. Where I have a short list of dates for that also.
So that we will hear. We are just interacting with you.
Right.
We are asking you.
Yes.
When there is such a heart-throbbing issue of scam, which you say that it has to be different definitions can be given. But it is a fact that there had been a scam in respect of several education.
But that will not vitiate the other selection process. One selection process said to be bad doesn't mean the other.
Can be argued against you that in order to divert from that issue, you are taking up the very basics as to whether there were any pleadings. Maybe this may be an argument on their side.
Yes, definitely. But I will deal with those also.
Yes.
But otherwise, the whole the writ jurisprudence has to be rewritten.
Yes.
Where your lordships have in a number of judgments held that whatever is there in the pleading as well as in the evidence, the court will only look into that.
Even except in extraordinary cases.
Yes. That extraordinary case has to be made out by the parties, not by the court. Court is not going to make out a case for one of the parties.
Yes. Yes, page.
Yes, ma'am. But I was placing paragraph 17.
Yes, 17. You have finished 17.
Yes. Now kindly take paragraph 18.
Yes.
Now kindly see how we are being dealt.
16 17 শুরু করুন।
Acha, 17 where I have not started. From the gross illegality in the selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its official so and so naita pora hoye gache. Now please take paragraph 18. This is very important for me. Kindly see how my arguments are being dealt with. It is a matter to be noted that the board in its affidavit in opposition while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable, those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that in the name of preserving the law, the corruption would be protected, with which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience, I say that in this recruitment scam, stinking rats are being smelled. So whatever rubbish I have said, that has to be dealt with by the court. Kindly see the next sentence. Even more alarming, the board placed some judgment before me in support of the niceties of the legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. These judgments are not required to be mentioned at all. But this is how, my lord, the advocate is being dealt. Say that these judgments are not applicable because of so and so reason.
At all in the facts of this.
No, he has not. I have referred to at least 20 judgments, not even recorded. That is why, my lord, with respect, my lord, the honorable court, my lord, bypasses the application of the principles by saying that these are niceties of law, as if, my lord, in writ court, niceties of law is not to be argued. It is a bhakchas court. Kindly see. Now, kindly see the expressions thereafter. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much, much above the ground realities, in which the unemployed youths live with tears in their eyes, because this recruitment scam is a crime against the society and also a fraud, where the board and its former chairman was well aware of the rules of the recruitment but cared a fig and started a play to hoodwink all concerned. I will only say that fraud unravels everything. Who has unraveled the fraud? Kindly, my lord, recollect.
Application yes. Yes, so there are total 44 appeals in this. We were told. Now those are arising out of the same judgment. Now how many petitioners were there in all these matters? Total number of petitioners, how many?
Milord, may I say this, Milord?
How many challenged the selection process?
140.
Only 140?
Only 140.
More than 140?
No.
140 retweets. Now, any other person came into the zone?
No, not in the appeal, before the writ court.
No, before the writ court we are asking. 140. All the 44 appeals, let us clear out the facts. All the 44 appeals are arising out of the same judgment. And all the appeals are dealing with the case of 140 writ petitioners. There were no other persons. whatever application for addition has been filed is by the teachers who are already in service. Right?
অনুরাগ আছে
Not only that, my lord, who are in the same footing of the petitioner, that application is also filed because their petition is also pending, and the board submission is that, my lord, due to this pendency of this matter, they are unable to address the court. So that's why the additional party and one of the additional party,
না না ও কেউ নয়, ওই অ্যাডিশনাল পার্টি এখানে অ্যাপ্লাই হয়নি।
One.
my lord, can too already on
হ্যাঁ এ বড় disturbing।
Yes.
কিন্তু কি বলছে কথা
in the first order it is mentioned, my lord, can too is already allowed.
Who are the unsuccessful persons? So do you have that chart? How many persons in total are there? Anyway, please ascertain that. Yes.
অনেক
Yes, Mr. Dotto. No breather. Continue.
And there are several petition pending.
Yes, we are on paragraph 20.
yes but I'll just finish this judgment Miller.
Yes.
Para 20
অনেকটা আছে দাদা।
Yes.
yes Then where paragraph 20, the affidavit in opposition of the board was filed when all pleadings of the petitioners, including the particulars placed in the court, were served and kept on record, and the board did not deal with those allegations and those material facts and necessary particulars. In such circumstances, I allow the writ petition. The appointment of all 36,000 who were untrained at the time of recruitment in 2016 recruitment process conducted by the board in the post of recruitment primary teachers were cancelled for various reasons as elaborated above. The board shall immediately arrange for a recruitment exercise. Rest is Miller how to implement the order.
So this fresh recruitment exercise which the single judge directed would be restricted to the self-same persons.
Yes.
Yes.
So my first is Millard,
Then
but the other is Millard how Millard the judgment is to
That
be
they
worked
will-
out. Yes.
such they will be acting as
Yes,
parateachers.
that may not be Millard
Yes.
essential for the present. Therefore, Millard, this is how Millard the litigation proceeded. Millard, one facet I have demonstrated before the court. The other is Millard as to when Millard the pleadings were called and what had happened in between. I'll place those also. Then Millard. But maybe come back after the vacation. Maybe.
Why vacation, sir? You can finish your argument at least, because your argument, your judgments we will take into account.
Wait.
How long will you take, Mr. Dotto?
Well, at least one half, another one half.
1 hour.
One half. Half of a day. Well, I have to show a lot of judgment. First is Millard, my judgments which I placed. Whatever judgments I have placed Millard has not been noted even.
Oh. On factual aspect, do you want to take us to any other document?
Yes, there are some other documents which I need to take care of. But these findings Millard are not based on anything.
Follow Kartik. First May.
আজকে কত? আজকে কত রে? আজকে হচ্ছে 7। I minded to hear it this side of the vacation, Millard. In that case, hey, bhai, okay. জজ সাহেবের সাথে কথা বলছি, তোরা তো কথা বলাচ্ছি। আমি যদি বলি ছুটি করে করবো, জজ সাহেব না বলে?
Yes.
Millard, in that case, Millard, kindly keep it, Millard, in
It
the.
is not we are minded, it is our work. We have to finish it.
Yes, yes, yes.
It is our work. We would only request the councils to
Well,
at
kindly
least you
keep
can
it, Millard.
shorten the time because it is awaiting decision for a substantial
Right,
period.
right.
That is a request to the councils. Now it is up to you people to come and tell us.
Millard, kindly keep it, Millard, in the week of 19th, starting from 19th.
Then
When-
on that day you are finishing your arguments, and it would
But
have
I
been
hope
very,
so, Millard. But I
very
hope.
helpful to us had we got the list of judgments which you are placing.
But that period I can supply to the court. Not today, but in between I can supply. That I can give. Ah, 19th.
And if on 20th 2 p.m. you cannot finish, if possible we will keep it as a continuing matter so that you can finish your argument. Prior to the vacation at least you can finish your argument. So that now it is their turn. You are added applicant, sir. Which appeal here? Achha, please let us know.
May I explain, Millard? May I explain, Millard? দাঁড়াও একটু এই পার্থ এক সেকেন্ড there are 44 appeals. One appeal is by the board. The other 43 appeals are by the successful candidates who have lost their job.
Right.
Or in other words, the 36,000 who have lost the job, many of them have preferred the rest 43 appeals. There are, Millard, certain.
Was granted to them.
Yes. And the applications which your lordships are facing, the addition.
The successful candidates.
No, they are the unsuccessful candidates.
Oh.
Standing on the same footing with the writ petitioners.
Or the rate petitioner.
Fence sitters will deal
I
with.
am the candidate.
There are also successful candidates who have not been implemented. They have also filed an application for leave to appeal.
That the other appearance to decide among themselves, go to the lead counsel among themselves.
That way, I think, this matter cannot be decided.
At least
Everyone
there
has
should
sight
be
of,
there should be a subject to what you say. The arguments can be urged before us by any particular advocate. If any further addition required, let that advocate continue. So I don't know.
The last
Pardon?
we will not repeat, but we may be given an opportunity to address it.
So you are the appellants, we will hear it. There is no problem with that.
The last question, my lord, also the same. Don't repeat. If you want to say something new, you are always welcome.
No, not new. You will certainly place your case. We are just requesting you, at least if one council can urge so that time can be shortened. No,
No repetition.
No, no, you decide that who will be the council.
Start after the vote, particular applicants, candidates.
So you sit together, sir. You don't expect the court to keep in abeyance for the entirety future. Don't insist unjustly. We have state very simple sentence we have asked. We have said if there are 10 councils, you decide that who is going to say something. Maximum 2 persons we will give. This way it cannot indefinitely continue. We will not allow that. This is we are. So you decide. We are not either Mr. Mitro or whoever is there. No, Mr. Devbarman, this way we cannot, because then what happened? Had Mr. Dotto adjourned till such and such. This we will do it for innumerable times to come. This court will not do. You wanting after vacation? We wanted that the original appellant will complete their arguments. That is Mr. Dotto and the other applicants who are similarly situated with them.
What happened, my lord?
Yeah, let us finish. So we will hear you, sir. We are wanting to curtail the time. So that is, we would again request you that let one council address us. Let one council or two council maximum. No, 3 or 4. PP cannot. So you tell us when will you argue? You tell us the date that we will argue on that. 20th, Mr. Dotto is finishing.
Finish করবে কি?
Very good. Then you are continue. So that we can finish off the persons.
Yes, Milord, before the vacation. Before the vacation, if your lordship, Milord, if your lordship permits. Yes, Milord, that will be the best. We can conclude it.
No, what we are just interacting with you. We cannot do on our own unless you assist. So we would be requesting the councils. We are fixing on 20th. Now, if suppose the person who will be arguing, he can continue till the next date. We can close the argument so far as the appellants are going. Please have something for us. There are 44 paper books we are put. So this is understood. So this is understood. We are keeping it on 20th. If Mr. Dotto will finish, and prior to the vacation, we will give you some occasion. You finish your arguments.
Yes.
You will get a chance to reply also. Let them start again. Mr. Dotto senior appearing for the appellants in the appeal.
My lord.
Lord, I will endeavor to conclude on the active.
Please.
Yes, I'll definitely, but
What submission is there? Will there be?
Sorry. Okay, sir. You are also for board. You are not for
Or addition of party. Handicap candidate. One handicap candidate.
Your addition of party applications are on record. Let us start. We will take up all applications on a single date We will hear you and we will add you or we will subtract you. Oh, subtraction to nahi hai. এইটা আমার would request that please make your submission